Okay, good afternoon. I'm not too sure whether I said 20 past 2 or 25 past 2. I'm not too sure. But if you guys are ready, we may proceed.
Yep, I'm here.
Did I say 20 past? Okay, so I'm
20 past, yes.
lovely. I don't want to short change anyone. So let's start. The last stretch of the presentation. It's been quite demanding over the past 2 days. As I said, it's not easy sitting here listening to yourself and not seeing the person that you're speaking to. But be that as it may, the last part that we need to discuss is the Apportionment of Damages Act and how the Apportionment of Damages Act is applicable to claims against the Road Accident Fund. Now, what I'm about to discuss, you don't need to study this in detail. I'll tell you what is it that you need to know of the Apportionment of Damages Act, but we must have some type of background regarding the Apportionment of Damages Act. So I'll read section 11A to you, and I'll try my best to explain it as simple as possible for everyone to understand. Section 11A of the Apportionment of Damages Act states where a claimant suffers damages which is caused partially by his own fault and partially by the fault of the person from whom he seeks to claim such damages, damages recoverable shall be reduced by a court to such an extent as the court may deem just and equitable, having regard to the degree in which the claimant was at fault in relation to the damages. Now, in terms of section 11A, as I mentioned yesterday, if your client failed to wear a seat belt at the time of the collision, and the client, for example, sustained a head injury, the RAF can rely on this section of the Apportionment of Damages Act by raising the argument that the extent of client's injury, I think someone's mic is on in the background. So the RAF may raise or rely on section 11A of the Apportionment of Damages Act and argue that the extent or the client's failure for not wearing that seatbelt contributed to the extent or the degree of the injury that the client sustained. So what I'm saying, just as a background, the Apportionment of Damages Act also states that more than one person can be sued. So you may have joint wrongdoers. So you may sue defendant 1 and defendant 2 in the same course of action, and they will be referred to as joint wrongdoers. Now, what orders can a court make in terms of the Apportionment of Damages Act? 2 possible orders. I'm going too fast here. 2 possible orders. The court can make an order that the joint wrongdoers, that damages be awarded against them jointly and severally, and that the one paying the other to be absolved. What does it mean? Let's say there's an order that the plaintiff is successful in for 100,000 rand. The court will make an order saying that the order is against both first and second defendant in that they must pay 100,000 to the plaintiff, but should the one pay, the other one is absolved, meaning the other one need not pay if the defendant 1 pays the full amount. Or alternatively, what the court can do in terms of the Apportionment of Damages Act, the court can apportion the damages and give separate judgment. For example, if it's an assault matter and plaintiff sued first defendant and second defendant, the court may make a finding that the first defendant was extremely vicious in her attack on the plaintiff, and that she contributed 90% of the plaintiff's injuries, and the second defendant merely contributed 10% of the plaintiff's injuries. In such an instance, the court can apportion, and if the total amount of damages is 400,000, the court can make an order against the first defendant for 90,000 that she must pay, and the second defendant must then pay the 10,000. I hope you are all still following, and I'm not going to force.
Mr. Yasin?
Yeah.
In respect of the first instance where the one is paying and the other is absolved, can you then institute a claim against the other wrongdoer to claim the amount that you paid back? Does that make sense?
If you, let's say you are defendant one, and you paid the full 100,000, and defendant two was supposed also to pay. The judgment was against both of you. Then the answer is no, you cannot unless it's separate. But if the order is against both of you, then either party must pay. And then my advice would rather be to institute a claim against the other party to have an order saying what degree that person was liable for the extent of the injuries. And then you'll be able to recover.
Okay, all right, thank you.
You're welcome. Now, the example that we gave now, plaintiff opted to sue both first defendant as well as second defendant. But it may be that plaintiff only sued defendant one. So the same scenario, there was an assault on the plaintiff by A and B. A was the vicious attacker and B not so vicious, but the plaintiff decides to sue B only instead of A, there's nothing wrong with that. However, B would like to get A before court as well, because B believes that A was the vicious one and A contributed more to the extent of the plaintiff's injuries. So the question is, how will A get B before the court? Defendant A must try and join B before the court as a wrongdoer. Now, question is what procedure must we follow in order to ensure that B is joined to this proceedings as a wrongdoer? A must send a notice in terms of section 2.2. So A must send a notice in terms of section 2.2 to B, giving notice that it is his intention to bring B before court as party to this proceedings. However, this notice can only go out before close of pleadings. So if you want to join parties to proceedings, you must send a notice in terms of section 2.2, that is not Desmond, just in terms of section 2.2, to the person that's not before court in order to join him to proceedings, but this notice must go out before close of pleadings. If it's after close of pleadings and you want to join the wrongdoer, you may only join if you get the leave of the court to do so. So The general rule is this notice in terms of section 2.2 must go out to the party you'd like to bring before court. However, it must go out before close of pleadings. If it's after close of pleadings, you may not send the notice in terms of section 2.2. You may not send that notice unless you obtained the leave of the court. Now, having said all of that, what is the actual procedure in the High Court versus the actual procedure in the Magistrates Court? That is what we will look at now. What is the procedure that we must follow to join a wrongdoer to proceedings, firstly in the High Court, and then secondly we'll look at the procedure in the Magistrates Court. So let's start with the High Court. High Court is governed by Rule 13, which is referred to as a third-party notice. In terms of the High Court rules, it is in terms of Rule 13, which is referred to as a third-party notice. Now, in the High Court, we will follow Rule 13. So we will send out this notice in terms of Section 2.2. Before close of pleadings, we are now in the High Court. We send the notice to the wrongdoer who we would like to bring or join as a party before court. Now, if you are the wrongdoer that I would like to bring before court, and you receive my notice in terms of Section 2.2 stating that it is my intention to join you to proceedings in this matter in the High Court. What do you think? What would be your options after receiving such a notice? Or how can you react to such a notice? You can either say yes or you can say no. Those are the only two options. Yes, join me, or no, don't join me to this proceeding. So those are the, yes or no, those are the options available. So let's look at the instance where you as the wrongdoer, after receiving the notice in terms of Section 2.2, you say yes to my notice. If you say yes to my notice, then you will be joined as a defendant. If you say yes, you will be joined as a defendant. This is now in the High Court. If you say no, you will still be joined to proceedings, but you will be joined as a third party. I'll repeat. We are now in the High Court. I am the defendant. I was sued by the plaintiff, but I feel that you must also be joined to proceedings because you are also liable for the injuries that the plaintiff sustained. Before close of pleadings, I send you my notice in terms of Section 2.2 that states that I give you notice that I want to join you to proceedings in this action. So we in the High Court.
I've got Teams training, darling. Yeah, so in the morning I connect for Teams.
I think Prudence, are you on? I think your mic is still on. Or someone's mic is on.
Yes. You know what happened?
I really don't know. If you can please switch off your mic.
Also paid.
Do we know whose mic is on in the background?
It's Prudence.
Okay, let me just phone her quickly.
No,
I think I'll just bear with me. I just want to send a message quickly.
Okay. It is an overpayment, yes. It's not a cancellation. They are both attending. And okay. Okay.
I'm just sending a message to switch off the mic quickly. Okay, her phone is off, but she's quiet now. Hi, Prudence, if you can hear us, your mic is on. We could hear your entire conversation you had over the phone. So if you don't mind, if you can please mute yourself. Okay, let's continue. Yes, this is what I was busy saying. I want to get you to join you to proceedings. I send you that notice in terms of section 2.2. We are in the High Court. You have a choice of either accepting my notice or rejecting my request. If you accept my request, you will be joined as the second defendant, because I'm already there as the first defendant. And if you refuse, you will be joined as a third party. Now, just as a background, Rule 13 requires, again, you don't need to know this. You won't be tested on Rule 13 for RAF purposes. You will not be tested on Rule 13. That is just merely for information purposes, that copies of all pleadings must also be given to you if you are joined as a defendant or if you are joined as a third party. But what is important? Following. Listen carefully, if you are joined as a defendant, judgment may be granted against you. So if you are joined to proceedings as a defendant, judgment sounding in money may be granted against you. So the court may make those two competent orders that I referred to earlier on. The court may either make a judgment that the one paying, the other be absolved, or the court may make an order for separate judgments where I must pay a certain amount as defendant one, and you must pay a certain amount as defendant two. Let me just check if I can get hold of her again, because it's difficult for me to concentrate if there's someone speaking in the background. I'll just try again.
Why is only that instruct?
Again later.
As off of phone. Hi, Prudence. Miss Mabena.
Okay.
Miss Mabena, can you hear us? Hello, Prudence.
Hello.
Hi. Hi, Prudence. Your mic is still on, so we can hear your entire conversation on the phone.
I'm sorry. I'm sorry. I've pushed it on because I wanted to hear you what time you conclude so that you can let me know. I truly apologize, everyone.
No problem. No problem. Thank you, Prudence.
Then my cell phone is off, so you won't be able to reach me.
That's correct. Yeah, that's correct. But if you can maybe just mute your mic, and then you will still be able to hear us. Thank you. Sorry, people. What was I saying now?
You were saying
court joined as a defendant, judgment may be granted against you.
Thank you so much. If you're a defendant, judgment can be granted against you in terms of those two competent orders that we referred to earlier on. If you can recall, we said that a court may make two competent orders in terms of section 28A. The court may either make an order that such joint wrongdoers or defendant pay the damages awarded jointly and severally, the one paying the other to be absolved, or the second competent order, the court can apportion the damages and give separate judgments. So that is if you're a defendant. However, if you joined as a third party, the court cannot grant any one of those two orders. The court cannot make an order that you must pay damages jointly or that or apportion the damages. The court may not grant those two orders. All that the court can do is to grant a declaratory order. Now, I'll explain that now. All that the court may do when you're a third party, the court may grant a declaratory order. So the court in its judgment will state that Shamil Jassim, you are the only defendant before court. The court finds that you must pay the plaintiff the sum of 100,000. And the court will continue with a declaratory order and state that you, Shamil Jassim, contributed 10% of the injuries that the plaintiff sustained and that the third party contributed 90%. But the order of 100,000 is against me as a defendant. So what I must do is, after judgment, I must satisfy the judgment. I will pay the plaintiff the 100,000, and after I've satisfied the judgment, after I've made payment to the plaintiff in the full amount in respect of the judgment, the 100,000 rand, I can then take this declaratory order without instituting proceedings against the third party. I can take this declaratory order and execute in terms of that declaratory order to recover the 90% against the third party. Everyone clear on that?
Yes, thank you.
Lovely. That is in the High Court. So let's look at the procedure in the Magistrates Court. What would be the procedure in the Magistrates Court? There's no similar provision corresponding to Rule 13 in the High Court. There's no similar provision. So what must you do? You must bring an application. If you're in the Magistrates Court, you bring an application to join the party to proceedings. And if you're successful in your application, that party is joined as a defendant. So whatever I said earlier on regarding the defendant in the High Court, it's applicable here to the defendant in the Magistrates Court as well. So let's now look at, by having that background now, knowing the competent orders that the court can grant when there's more than one wrongdoer, so when there are joint wrongdoers, the two competent orders. Now having the background regarding a third party and a possible defendant that can be joined to proceedings, and what the procedure would be in the High Court versus the procedure in the Magistrates Court, let's turn our focus to claims, the Apportionment of Damages Act on claims against the Road Accident Fund. Let's look at an example. I am claiming from the Road Accident Fund. I was the driver of motor vehicle A, and I was involved in a collision with motor vehicle B driven by B. Both of us failed to stop at a four-way intersection. I sustained bodily injuries. I now lodged a claim against the RAF and I caused a summons to be served on the RAF. So I'm the plaintiff and the RAF is the defendant. Now, based on what we said yesterday, the RAF will step into the shoes of the common law wrongdoer, or as the Act states, the RAF will step into the shoes of the insured driver. Now, in this example, I was the driver and there was a driver B as well. In this example, into whose shoes will the RAF step if I'm the plaintiff?
Into B shoes.
Absolutely correct. Because the RAF cannot step into my shoes, because if they step into my shoes and they remove themselves, I'm suing myself. So they are stepping in the shoes of B, who is the common law wrongdoer. Absolutely correct. So you are now acting for the RAF. You acting for the RAF. Their insured driver, who is B, the common law wrongdoer, was 50% to blame for the accident. And I'm the plaintiff, I was 50% to blame for the accident. Do you think it is necessary for the RAF to send out a notice in terms of Section 2.2 of the Apportionment of Damages Act? Or how would the RAF go about to ensure that they recover remember, I contributed to this accident, so how can they get my contribution? Any volunteer?
Do they just simply not pay out more than 50% of the claim?
Okay, correct. But now the problem is the defendant, who is the RAF, can, if the court orders that they must pay me my damages, they can't refuse to pay, or they must pay the entire 100%. They can't refuse to pay whatever other percentage. So how can they ensure that they get a court order against me for that 50%? Maybe let me rephrase it that way. But you're on the right track.
You have to bring an application in terms of Section 2.2.
Okay.
Joined.
Okay, let's consider that. We consider all options. If they bring an application to join me to proceedings, so you are now acting for the defendant, the RAF, you send that notice in terms of Section 2.2. I receive that notice, I say yes. We're in the High Court, so I say yes. I will be joined as?
Defendant.
Defendant. And who is the plaintiff in this matter?
You
are.
I'm the plaintiff, I'm driver A, so I'm the plaintiff. Now just let us think this one through. If I'm the plaintiff, how can I also be the defendant? Does it make sense?
No.
Not at all. So that option is not available to us. But I want you guys to reason this one through as we're now doing. So we can't even send a notice in terms of Section 2.2. So what must we do for the defendant, the RAF? What should happen? The RAF must file a plea, and in the plea, the RAF must plead contributory negligence. And if they plead contributory negligence, they may get the benefit of a reduction of my claim. And this is important. It was already asked in previous exam question papers that candidates should draft the part of the RAF's plea pertaining to contributory negligence. So if you get your manual or your soft copy of the manual, please ensure if you study, have a look at the RAF's plea, especially the part pertaining to contributory negligence. So there you can see, we gave you an example now as to when the RAF in its plea can raise contributory negligence, and the example is where the plaintiff was a driver and the RAF steps into the shoes of the other driver who is the insured driver of motor vehicle B. In that case, to ensure that the RAF gets some reduction or benefit of a reduction of my claim as the plaintiff, the RAF can plead contributory negligence. Everyone happy with that explanation?
Sorry, can you please go through that again? When does RAF put in the averments with regards to the plea of contributory negligence, and in the plea, when you're drafting the plea with regards to the contributing negligence, isn't it just 1 or 2 points? Because I have done this before. I just can't remember exactly why I did it when I did it.
It's a paragraph. If you get your notes, it's a paragraph where you allege that the plaintiff, let's answer you from the back. It's a paragraph in a plea where the defendant, the RAF, will allege that the plaintiff also failed to keep a proper lookout and that he failed to stop at the four-way intersection, and that his action he was also negligent, and based on his actions, you're requesting that the court apportion his claim according to his degree of negligence. So it's a paragraph that you add in the defendant's plea. That's the.
So if they ask you to draft the plea, do you just do the paragraph, not the whole plea?
Correct. Only the plea. In previous exam question, as I said, not once did they ask you to draft a entire particular subclaim, nor did they ever ask students to draft an entire plea. But what they did in the past, they asked students to draft the contributory negligence part of the plea, and for particular subclaim, they asked students to draft the citation of either the plaintiff or either the defendant. This morning we looked at the citation for minor children, and since yesterday we've been mentioning section 2.3, the citation of the defendant. So to answer your question, they may ask you to draft only this part of the plea pertaining to contributory negligence. And then the first, yeah.
Sorry to interrupt you, sir. I was cut off due to poor network quality.
Okay.
Can you just explain to me from where the RAF must plead contributory negligence?
Are you referring to the example?
No. I was still with you when we said RAF must file a plea, and in the plea they must plead contributory negligence. That's where I got lost.
Okay, that is basically where we ended off.
Okay.
That I'm just now answering another student that did not understand, but you are with us. That is where we ended. That
okay, thank you.
Get a contribution, the RAF must plead contributory negligence to get a benefit of reduction. Lovely.
Excuse me, sir.
Yeah.
Sorry, I just have a question. With regard to how does this kind of fit in with normal insurance? For example, if you have your vehicle insured as well, and you are in this situation.
Yeah. How does it fit in?
Yeah, so if you have your private insurance already.
Okay, For damages to your motor vehicle or for personal injury?
Both, I suppose.
Okay. For damages to your motor vehicle, that is not covered by the RAF. So that would be covered by your own personal insurance. Remember, RAF only covers bodily injury, personal injury to your body. So if it's damage to your motor vehicle, that you will recover by an ordinary civil case against the person who caused the damage, or you can go against your you can claim from your insurance company, and the insurance company will recover it from the person that's liable to pay the damages. Now, you do find some insurance companies that also offers cover for personal injury in motor vehicle accidents. Again, I've got my own personal opinion on that. I don't subscribe to such a policy, or I won't subscribe or take out such a policy. Why? Because the RAF covers personal injury, so you don't need to take out additional cover for personal bodily injuries, because the RAF steps into the shoes of the common law wrongdoer. So that is just my personal opinion, that insurance companies will provide such cover, but if you look at it, there's no need for such a cover. So you're paying a contribution. If you injure someone in a motor vehicle, in terms of RAF, the RAF will in any event step into your shoes. So the RAF will compensate that person. That person cannot sue you in terms of Section 21 of RAF. The RAF is substituted for the common law wrongdoer. Okay? The CA asked me how or when can the RAF plead contributory negligence. The RAF, the example that I gave earlier on, I was the driver of motor vehicle A, which collided with motor vehicle B at a four-way intersection, and both of us failed to stop. So I failed to keep a proper lookout, so did the driver of motor vehicle B, so we equally to blame. In that case, the RAF will step into the shoes of the driver of motor vehicle B, and the RAF need not bring me before court or as a party to proceedings. I'm already there. In that case, the RAF will merely plead contributory negligence in its plea. Another example
Sorry, can I ask a question?
Yeah.
How do you know, how would RAF know that it is contributory negligence? Because if the other party said that if both parties said that they did look, but obviously they're not saying it in the vermins of the plea correctly or of the summons.
What happens in practice is that if the RAF is being sued, the RAF investigators will go out to the insured driver and obtain a statement from the insured driver as to what happened. So based on the statement from the insured driver, the RAF it's easy to come to a conclusion then, or they would be able to make a determination regarding the merits to see whether or not myself as driver A, whether I also contributed to this, or whether I was also partly to blame for the accident. So in any litigation, there will always be more than one version. You will always have the version of the plaintiff and the version of the defendant. If we don't have those two versions, then there's no need for litigation, because then it's a clear cut. So in litigation, there will always be two versions, the one for the plaintiff and one for the defendant. I hope I answered your question. Let's look at another scenario.
Yes, thanks.
Welcome. Let's take another scenario. The scenario we now use is where I was a driver and I claim from the RAF. Now, I had a passenger in my motor vehicle. So I had a passenger in my motor vehicle. Same scenario, I failed to stop as driver A, so did the driver of motor vehicle B. We both failed to stop at the four-way intersection. The passenger in my motor vehicle, let me be safe and say it's my wife, because if it's another female, I may end up in trouble. So let me rather be safe. She's somewhere here in the house. So my wife was my passenger in my motor vehicle, and she sustained an injury. She lodges a claim against the RAF and also caused a summons to be served on the RAF. So she is the plaintiff and the RAF is the defendant. Let's again reason this one through. Into whose shoes will the RAF step? She was a passenger in my motor vehicle, and my motor vehicle collided with motor vehicle B. So there's the driver of motor vehicle B, which is B. My wife is claiming as my passenger. Yesterday we mentioned the passenger must show 1% blame on the part of the other driver. So it's easy for her to show that 1% because we both failed to stop. So the plaintiff is my wife, RAF is the defendant, and the defendant will step into the shoes of driver B. So driver B in this example is the insured driver for RAF purposes. Driver B is the common law wrongdoer, who is also referred to as the insured driver. In this instance, can the RAF, because my wife is the plaintiff now, can the RAF plea contributory negligence? What do you think?
Yes.
Okay. Someone is saying yes, someone is saying no. Let's start with the first one who answered the yes. Let's reason it through. If the RAF plea contributory negligence and they're successful with their plea in respect of contributory negligence, whose claim will be reduced? The plaintiff's claim will be reduced. Am I right? The passenger who is the plaintiff, her claim will be reduced. So if her claim is reduced, did she fail to stop at the four-way intersection?
No.
No, she was merely an innocent passenger. Remember, since yesterday we said that negligence can only be attributed to a driver and never to a passenger. So I don't want to say my wife is innocent. My passenger is innocent. She's not always innocent, but let me be serious now. Let's say my wife is the innocent passenger. So if her claim is reduced, it won't be correct because I was the one that failed to stop as well and she was innocent. Hence, we cannot, or hence the RAF cannot plea contributory negligence. What other option would be available for the RAF to get some benefit from my side? Am I before the court? Am I part of this proceedings?
The RAF waived you in terms of Rule 13.
Correct. What must happen? The RAF can send a notice, absolutely correct. The RAF can send a notice in terms of Section 2.2, read with Rule 13, if you're in the High Court, to me, because I'm not part of the proceedings, they can inform me that they intend to join me to proceedings. If we're in the High Court, I can accept. If I accept, I will be defendant 2. RAF will still stay first defendant. Or if I refuse, I would still be joined as a third party. And we know if I'm joined as a defendant, what are the 2 competent orders the court can grant? They can make, the court can grant a judgment that both myself and the RAF pay my wife, or they can give separate judgments where my wife's claim is for 200,000 Rand. The court can make an order that the RAF is 50% liable because they're stepping into the shoes of driver B. They must pay my wife 100,000 and I'm 50% to blame. As defendant 2, I must pay my wife 100,000 Rand as she was the passenger. Everyone clear on that?
Yes. So is this only in situations where the plaintiff was a passenger?
Correct. In the example that we're using now.
Okay, thank you.
You're welcome. Okay, let's take it a step further. Let's take it a step further. I'm driving with a passenger in my motor vehicle, and the passenger is accompanied by her minor child. So it's myself, my passenger, and the passenger's minor child. The passenger is seated next to me on the front seat, and her minor child is sitting on her lap. So I hope you're getting the picture. I'm the driver, my passenger is seated next to me, and my passenger's minor child is seated on her lap. I, again, at the 4-way intersection, I failed to stop. So did the driver of motor vehicle B. So both myself and driver of motor vehicle B failed to stop at the 4-way. So both of us are equally to blame. My passenger decides, the minor child sustained bodily injury, more specifically head injuries, and my passenger, who is the guardian, the mother of the minor child, sustained no injuries. Why? Because she was saved by the minor child sitting on her lap. The minor child sustained the impact and sustained the injuries, and that saved my passenger from sustaining any injuries. So passenger lodged a claim on behalf of the minor child. So this child was hospitalized. My passenger is now claiming general damages on behalf of the minor child, as well as medical and hospital expenses. So there are 2 claims. The one is in her representative capacity, which is on behalf of the minor child, and the second one is in her personal capacity, that is in respect of the medical and hospital expenses. Everyone understand the scenario?
Yes, thank you.
Okay, so that is the scenario that we're facing. We must now give advice to the Road Accident Fund. The Road Accident Fund received a summons from this lady, and in the summons, the lady is the plaintiff in her personal capacity for hospital and medical expenses, and she is the plaintiff another plaintiff, she is also there in a representative capacity on behalf of the minor child. So the plaintiff is my passenger in a personal capacity and the minor child duly assisted by the guardian who is also the plaintiff. We must now give advice to the RAF as to how we can get some type of contribution from the lady who was the passenger. Let's break it down and look at the claim in her personal capacity. How would we ensure? Firstly, do you agree that the passenger contributed to the extent of the injuries that the minor child sustained? And the reason why I'm saying that is she allowed a minor child to sit on her lap on a front passenger seat, and because that child was seated on her lap in the front passenger seat, that contributed towards the head injury that the child sustained as a result of this collision. Everyone with me?
Yes, sir.
Yes, sir.
So, the Apportionment of Damages Act is indeed applicable. So what advice can we give the RAF as to how to proceed to get some type of benefit from her claim? So we said there are two claims, the one in a personal capacity. The one in a personal capacity, if she's successful, who will get the money?
She will.
She will. So how can the RAF get the contribution from her or reduction from her from that claim? Should we join her to proceedings?
Can't we join her to the proceedings where she's acting as a representative of the minor?
Bear in mind, it's one summons that was served on the RAF. So the case before the court is that in this case she's the plaintiff and she's the representative on behalf of the minor child. She's there already before court as a plaintiff and she's before court as a representative of the minor child. So if we send her a notice in terms of section 2.2 and she accepts that notice, we are facing a difficult task in court because now imagine you must introduce this lady, you're acting for this lady. My lord, my lady, I'm acting on behalf of the plaintiff in her personal capacity, and she is here in a representative capacity on behalf of the second plaintiff, who is a minor child, and she is joined to proceedings as the second defendant. That would be a whole mess, am I right? Which means we cannot join her to proceedings. She's already before court. What did we say in our first example? How will we get a contribution? By pleading contributory negligence. Everyone clear on that? So in the claim in the personal capacity, the advice to the RAF would be the RAF must plead contributory negligence. Any questions based on that?
No.
Lovely. So we're all still following. So let's move on to the claim in her representative capacity. We are now looking at the claim in her representative capacity. So again, the same two options. The option is we either join her to proceedings or the RAF can plead contributory negligence. This is the same matter If we join her to proceedings, we are facing the same difficult task that she is the plaintiff in her personal capacity, and she is there in a representative capacity on behalf of the second plaintiff, who is a minor child. And if we join her to proceedings, she's either joined as a third party or a second defendant. So joinder is out. In the case for representative capacity, joinder is out. We are only left with the last option, which is a plea for contributory negligence. If the RAF plea contributory negligence in her claim, in the claim where she's there in a representative capacity, if you can recall this morning, what did we say in the case of a minor child? Who is the party before the court? The guardian or the minor child?
The minor child.
The guardian.
No, the minor child is the party before the court. So if we are asking the court to make a reduction of the claim in her representative capacity, whose money are we taking away? Her money or the minor child?
The minor child.
The minor child.
The minor child. And who was to blame? Was the minor child to blame or the guardian for the extent of the injury?
The guardian.
The guardian. Hence, it would be unfair if the court grants an order for contributory negligence in the claim in her representative capacity. So that is also out. The only option available to the RAF is what we call to file, I think I have it here, is to file a conditional counterclaim. So the only option available for the RAF is to file a conditional counterclaim. So the question is, when will a conditional counterclaim be filed by the RAF? A conditional counterclaim will be filed by the RAF, where the plaintiff is there in her personal capacity and she's there in a representative capacity on behalf of the minor child. But in the case of her being there in a representative capacity as well as personal capacity, the RAF can not ask contributory negligence here, but the RAF will file a conditional counterclaim. It's as easy as that, people. Everyone clear on that?
Yes, thank you.
Lovely, and that is my story. But I promise you that I will try and get you some previous exam question papers pertaining to RAF to show you the type of questions that you can expect during the exams, and I managed to pull questions from previous exam question papers for you. I'm not going to do all of this. I can make this available to you as well, together with a memo, which I will only be able to attend to by the weekend. So by next week, if you want this, you can just send me an email asking for the questions and the memos of the previous exam question papers that I've put together. But just to show you quickly the types of questions that were asked in previous exams, let's look at question 1. I'll read it and see if we can just quickly go through it. Question 1. X was a pedestrian who was injured on 15 May 2011 due to the negligent driving on the part of the insured driver. The insured driver is the common law wrongdoer, as I mentioned earlier on. A third-party claim on behalf of X was lodged with the RAF by a claims consultant. The RAF refuses to entertain X's claim. Is it, so they're asking, is the RAF entitled to do so? Give reasons for your answer. 3 marks. Now, before we give an answer, where this morning, if you can recall, under which section this morning did we discuss something like this regarding who may prosecute claims?
Section 19.
19.
Lovely. There you've got your first mark already, just by saying we're looking at section 19. And what specific provisions of section 19 do you think it's applicable here? Who may prosecute?
Yes.
What did we say? Who may prosecute?
An attorney
Yeah,
or the injured party.
correct. May a claims consultant, remember I referred to it as an ambulance chaser this morning. May a claims consultant lodge a claim on behalf of a client?
No.
No. So is the RF entitled to refuse to entertain X's claim?
Yes.
Yes. Perfect. There's your 3 marks. You see how easy it is, people, and how you should interpret these questions. Read carefully as to what they're asking for. Let's just look at question 2 as well. Your client, who was 14 years old and a fair paying, so it was a fair paying, let me just, I'm now in the exam, so I'm highlighting everything. It was a fair paying on a motorcycle, was injured on 15 June 28, 2008, and this accident was caused by the negligence of the driver of the motorcycle.
So it's old act and it's a minor.
Okay, before we get there, let's start with the date of accident. Which act is applicable?
The old act.
The old act. Lovely. So the old act, and look at words which I've highlighted. I've highlighted motorcycle, fair paying. Another word for fair paying would be for reward, and negligence of the driver of the motorcycle. Where did we mention this morning?
Section 19.
Section 19. There you have your 1 mark. What did we say about section 19?
Priscilla's mic is on.
What did we say about section 19 this morning regarding a passenger for reward, or a fare paying passenger, as they're saying here, who is on a motorcycle and where the driver was solely to blame for the accident? Is there a claim against the RAF?
Yes. No, it falls under the exclusions.
It falls under the exclusion, and that exclusion is only applicable to the old act or the new act? Old act. We're dealing with the old act, so that exclusion is applicable here. So your answer will be simple, that in terms of section 19, there's no claim against the RAF, and the words I've highlighted, that is the reasons you will provide why there is no claim against the RAF. The 3 requirements: it was a fare paying passenger on a motorcycle, and the driver of the motorcycle was solely to blame for the collision. There you go, 3 marks, already 6 marks in the bank. Do you feel comfortable answering questions now for RAF? I just want to go through some questions still, just to give you, see what is question 3. Let's look at question 3. You are consulted by a father whose son was killed on 6 June 2011. So what did I say? In the exam, highlight the date of accident. So on the 6th of June, the person, so this is the new act. In a motor vehicle collision, due to the negligence of the driver of motor vehicle, and they give us the registration number, the father produced statements of accounts which consist of the following items, and there are the 4 items together with the costs. Advise your client as to which items and what amounts. So it's not only the items, they're looking for the items and the amounts that may be claimed from RAF, and you must provide reasons. So this is 3 marks. Which category? Okay, first start, which category of claims are we dealing with here? Of damages are we dealing with here?
Funeral expenses.
Funeral expenses, correct. We're dealing with funeral expenses. Are there any differences between the old and the new act pertaining to funeral expenses that we must know of?
No difference.
No.
No difference. It's treated exactly the same. Lovely. So this is how you must approach the questions. You need to ask these questions in your mind. So it's exactly the same. So the date of accident won't help us here because it's exactly the same between the old and the new act. When will the RAF compensate funeral expenses? What is the general rule?
They will only compensate for necessary expenses.
Lovely. And what are those necessary expenses? When will it be necessary?
Either to get in the grave. Put the person. What did it take to put the person in the grave? Not who was attending the funeral.
Okay. There was another lady that wanted to say something as well.
It's either to put a person underneath the ground or to cremate the person. So it would be the coffin and the undertaker.
Okay, so perfect. Let's work with that. The necessary cost to either place the body in the ground or to cremate the body of the deceased. That you must write in your answer. That is the reason that you will provide, and you will provide that reason for the items that you identify. Is it necessary for there to be a coffin?
Yes.
Yes.
Yes. So you will say yes, it is necessary. It was necessary to be a coffin, but remember they want the amount as well. Then you list the amount. So they'll give you half marks. Then you say the RF will compensate the coffin cost, 2,000 Rand. Is it necessary for there to be an undertaker?
Yes.
Yes. That's another 2,500. A gravestone?
No.
Not necessary.
No. Refreshment costs for the, as I said, the mourners instead of the mourners?
No.
No. So your answer will be, the items will be coffin costs. You will add the 2,000. The cost of the undertaker, 2.5. The total amount that client will receive is 4,500 Rand. And there you go, another 3 marks, easy 3 marks for you in the bank. Any questions?
Sorry.
Any questions regarding that specific question? Let's see. Let's look at question 4 as well. Who must complete and sign the medical report attached to the claim form, which must be lodged with the RAF? What did we say? Who must sign that claim form?
The superintendent or the medical practitioner.
Correct. 4.2, if the party required to complete and sign the aforesaid medical reports or is unavailable to do so, who can be approached to complete and sign the same? Remember, I mentioned this to you this morning.
Any other doctor.
And what must that doctor do? You can't just say any other doctor.
He must do a medical report on the plaintiff.
Correct, and he must also ask the claimant about the medical history, and that would be recorded, and there you get your 2 marks. I just want to see something that I did not cover. I want to bring it to your attention. Okay, we covered question 5. But let me just look at question 5.1. After close of pleadings, the RAF makes a settlement offer which is acceptable to your client. So the RAF makes a settlement offer. 5.1. How do you advise the defendant? The defendant is the RAF of your client's acceptance of the offer. It's so simple, people. All they want you to say, you give them a written notice of acceptance. That is the answer. Remember what I said yesterday about the exams that you wrote at university versus this exam. This is not technical. This is straightforward. So try and not complicate things for yourself. Here they're looking for straightforward answers. All you must say, give them a written notice of acceptance. There you get your 1 mark. 5.2, you only receive the check in terms of the settlement 2 months after the offer is accepted. Is your client entitled to interest? And if so, from when and at what rate?
14 days after.
No interest because there's no court order.
Absolutely correct. That's all you say. No interest. In terms of section 17, there must be a court order before your client will be entitled to interest. 5.1, 5.3, what can you do if after acceptance of the offer, the fund fails or refuses to pay? So you have an offer and the offer was accepted. What can you do? Don't overcomplicate things. What do you think? What would be a simple answer? There's an offer, there's an acceptance. You make the offer an order of court. You don't even need to issue summons. You can obtain judgment in terms of that offer and acceptance. So you just go to court and make the offer and acceptance an order of court and apply for judgment. That's it. How it works in practice, if there's an offer and acceptance, you give them the RAF 5 days notice in writing that you intend to go to court to make this offer and acceptance an order of court, and you then have to apply for judgment. I want to see. Oh, question 6.
Sorry, I'm a bit confused with 5.3. Is this in the initial stages where the client accepts the offer? Is it the offer that RAF made previously, or which offer to do the court order?
It's the offer that your client accepted. So if there's an offer on the table and your client accepted the offer by giving RAF the written notice of acceptance, and after giving the written notice of acceptance, so there's now an agreement that they will pay in terms of the offer. If they fail to pay in terms of the offer, now you can apply to court by giving 5 days notice to the defendant. You can apply for judgment in terms of that offer and settlement. Okay. Question 6. I don't feel like reading, but I have to because we require the facts in order to answer the question. Question 6. You are consulted by your client who explains the circumstances of a motor collision in which he was involved. He was a passenger in a vehicle which collided with a truck. The driver of the truck was solely responsible for the collision. Your client suffered a broken femur, a broken ankle, and a broken collarbone in the collision, and his wrist was severely dislocated. As a result, he was hospitalized for 2 weeks, and when discharged, was still on crutches and obliged to stay at home for another 3 weeks. Only then could he return to work. Whilst away from work, your client was paid in full, although he was only entitled to 3 weeks sick leave in terms of his employment contract. 6.1. What amount can your client claim for past loss of earnings in these circumstances? Motivate your answer. So they saying client was off sick for 2 weeks and he was discharged and he stayed at home for another 3 weeks. So client was off from work for 5 weeks. He was off from work for 5 weeks. His company paid him for the entire 5 weeks. He was paid in full for the entire 5 weeks. However, in terms of his employment contract, he was only entitled to 3 weeks sick leave. The question is, what amount can your client claim for past loss of earnings in these circumstances? Even though your client received compensation for 5 weeks, even though he received compensation, he was only entitled to 3 weeks sick leave. So if he got paid sick leave, he cannot, there was no loss of income because he got compensation for that period. So he got compensation for 5 weeks, but in terms of his contract, he was only entitled to 3 weeks, which means that his company gave him 2 weeks extra. They paid him 2 weeks extra, even though he was not entitled to that. They gave it to him as one can argue they gave it to him as a gift. Now, in terms of labor law, that is referred to as an ex gratia payment. Correct, an ex gratia payment. Now, ex gratia payments are not taken into consideration when quantifying claims. So if we say ex gratia payments are excluded when calculating the loss of earnings, he then only received, if we exclude the ex gratia payment, he only received payment for 3 weeks and he was off for 5 weeks. So for how many weeks must the RAF compensate him for loss of earnings? For 2 weeks. Everyone clear on that?
Yes.
Thank you. 6.2. From which medical specialist would you obtain a medical legal report to substantiate your client's claim for general damages? We're dealing with bones, so that would be an orthopedic surgeon. 6.3, your client's wristwatch. Your client's watch was damaged beyond repair in the collision. May he claim the replacement cost from the fund?
No.
No.
No, why not?
It's not a bodily injury.
Perfect. Yeah. That's it. There you get your 1 mark. So there you get your 1 mark. I just want to see, where's the other one I want to... question 12. Let me go to question 12. You are consulted by Mary Smith, who advises you as follows. On 1st of April 2011, so that is the date of accident, 1st of April 2011. A collision occurred between a vehicle driven by her husband and another unidentified vehicle. The driver of the unidentified vehicle was completely to blame for the collision. Mary's husband sustained bodily injuries from which he died on 15 April 2011. There were 4 minor children born of the marriage, and the eldest 3 were doing well at school. The deceased was 45 years old when he died, was employed at a gross salary of 30,000 Rand per month, and would have retired at the age of 65. Ms. Smith was 40 at the time. Mr. Smith left a will in terms of which a testamentary trust was created for the benefit of his children. He had 2 life insurance policies, and the trust to be formed was nominated as the sole beneficiary thereof. The other vehicle which collided with Mr. Smith first collided with a pedestrian, and the driver thereafter lost control of the vehicle and collided with Mr. Smith. Mrs. Smith hands to you several vouchers in respect of hospital, medical, and funeral expenses that were incurred, which she paid. You advise your client that there are certain claims that can be made against RAF arising from the death of Mr. Smith. Answer the following questions with the above named factual information. A. Identify the claims that are available and also furnish the identity of the claimants in respect of each claim. Now, to save time, I'm going to mention it to you. There's a claim for loss of support on behalf of Mrs. Smith as well as her children. And there is a Mrs. Smith provided you with vouchers for the past medical and hospital expenses. So Mrs. Smith there's a claim for her in a personal capacity for the past medical and hospital expenses. And it's stated that she paid the funeral expenses. So Mrs. Smith can, in a personal capacity, can also claim funeral expenses. So Mrs. Smith can claim in her personal capacity. Mrs. Smith can claim loss of support for herself and claim past medical and hospital expenses as well as funeral expenses. And in her representative capacity, Mrs. Smith can claim loss of support on behalf of the minor children. We all understand how I came to that conclusion. B, to substantiate the claims. To substantiate the claims, certain documents have to accompany the claim form in respect of each claim. Name these documents. So I've identified a loss of support claim. In respect of the loss of support claim, because she was married, you need the marriage certificate. Because Mr. Smith died, you need the death certificate. Because there's a loss of support claim for the minor children, you need the unabridged birth certificates of the minor children. Because it's Mr. Smith died, the claim accompanied by the claim form must be the post-mortem report or the inquest report, as we mentioned this morning. And to prove his salary, you need to submit a copy of his salary slip or a salary certificate which the client can obtain from work. That is in respect of loss of income. And in respect of the medical and hospital expenses, to prove that, Mrs. Smith must just submit the vouchers or the invoices, and in respect of funeral expenses, Mrs. Smith must submit the invoices. That's it. And C, they want you to draft the citation of the plaintiff. Remember, the citation of Mrs. Smith is here in a personal capacity as well as her representative capacity. So please have a look at your notes. You will find an example of the citation in the notes. Am I going too fast or are you still following?
Yes.
Following.
Lovely.
Oh, yeah.
Lovely. D. In the event of any claims being available to your client on behalf of herself and the children, for what periods will your client be able to claim? So they don't want to tell us directly the claim in respect of loss of income, because if they tell us loss of income here, they're giving us the answer to A. So here they're saying, in the event of any claims being available to your client on behalf of herself and her children, for what periods would your client be able to claim? Remember, she's claiming loss of support for herself and she's claiming loss of support on behalf of the minor children. Let's start with the minor children. Loss of support for the children. Maintenance is claimed either till the age of 18 or until the child is self-supporting or self-sufficient. So in respect of the minor child, either till the age of majority, which is 18, or until the child is self-sufficient or self-supporting. And for the widow, for Mrs. Smith, remember they said, if we go back, Mr. Smith would have worked until the age of retirement. What did they say here? He would have retired at the age of 65. And he was 45 years old when he died. So he would have worked for another 20 years, and Mr. Smith would be able to claim loss of support for that 20 years period. Everyone clear on that? So he would have worked till the age of 65, he was 45, so the widow would be entitled to compensation for a period of 20 years till the date of retirement. E. How will the deceased income be apportioned amongst the claimants? Now they say that he earned a salary of 30,000 Rand. There are 4 children and Mrs. Smith. So they are 5 in total. Obviously, each claimant cannot receive 30,000 Rand. There are 5 of them. If they each must receive 30,000 Rand, they will be making 150,000 Rand per month from the RAF, even though Mr. Smith only earned 30,000 Rand. If that is the case, I think most of us will go and push our breadwinners in front of cars for them to die in order for us to increase the amount of compensation in respect of loss of income. So obviously, for obvious reasons, each one will not get 30,000. That 30,000 must be a portion between the surviving spouse and the children. The method is the surviving spouse will get 2 parts and the child will get 1 part. So the surviving spouse will get double the amount of what the child would receive. That's all you need to know. You need not calculate the amount. The surviving spouse always gets double the amount that the child will receive. Everyone clear on that?
Yes, thanks.
Okay, and if I'll be ending now soon. If in your assessment of the claims on behalf of the children, will you have to take into account the monies that they will receive from the trust created by the deceased in terms of his will? Motivate your answer. Remember the fact stated that there will be a trust form and the children will be the beneficiaries. The answer is no. It will not be taken into consideration. The reason for that is, in terms of the Assessment of Damages Act, inheritance are excluded when dealing with the Assessment of Damages Act. So that amount that they would be receiving in terms of the trust to be created will not be taken into consideration. And then G, will the proceeds of a life policy accruing to the estate have to be taken into account when they're assessing any of these claims? The answer is no. Again, in terms of the Assessment of Damages Act, the same way inheritance are excluded, the proceeds of life policies are also excluded. By what date will you have to lodge? They're now not asking about the summons, but they're asking about to lodge the claim forms in respect of each of the claims that may be available. So they want us to calculate prescription. They told us it's an unidentified vehicle. If it's unidentified, is it identified or hit and run?
Identified is not hit and run. Unidentified is hit and run.
Correct. I'm asking if they say unidentified, is it identified or is it hit and run?
That's a hit and run.
Hit and run.
Correct. How many years to lodge?
2 years.
Lovely, 2 years. Remember, prescription, if it's a fatal, it starts from date of death. If it's non-fatal, date of accident. The accident date was on the 1st of April 2011, and he died on the 15th of April 2011. So is this a fatal or a non-fatal injury?
Fatal.
Fatal. So are we starting our prescription from 1 April or 15 April?
15.
15 April. Lovely. So if we start from 15 April, what is 11 plus 2?
2013.
13, correct, 2013. April, day before, 14th of April. Lovely. I'm happy. I'm happy that you are good to go and write the exam without studying. I'm confident that you will pass this exam without studying. I can hear from what you're telling me that you know exactly what's going on. So from my side, people, it was an absolute pleasure to present this class to you, even though it was the first time for me to present these classes online. I think it went well. I thoroughly enjoyed all your participation. I wish you all the best and all the luck for your future endeavors. And I hope to meet everyone in person once it's possible. So if you do see me at court or wherever, come to me, come up and tell me that you were in this class. It's always nice to engage with the candidate attorneys. So from my side, I thank you for listening to my nonsense. Hopefully my nonsense will help you with your exams. And please stay safe and take care. Cheers, everyone.
Thank you.
Thank you so much.
Bye.
Thank you.
Thank you.
Mr. Yasin,
Yeah.
are you a marker for the exams?
No, you see, I'm one of the presenters, and then there are different examiners that mark. So I don't want to take that responsibility.
Thank you.
Why do you want me?
Thank
you
you
want
so
you want
much for
to?
being so interactive with us. You have done a lot. Thank you so much.
You're more than welcome, everyone. Everyone, stay safe and be good until we meet in
Thank you
person.
guys also for being so interactive during the time that we were doing this whole lecture, because a lot of people asked a lot of questions that I didn't ask, and you guys have been very helpful. Thank you guys so much. From Stellenbosch Legal Aid, thank you.